great pleasure to introduce Dr. Barbara Havelková. She is a Shaw Foundation Fellow in Law and is at Lincoln College, Oxford at the moment. However, she's been with us for quite a while. She did her DPhil here on gender law under and after. A bit that warm.
Under and after 6 months.
Yes, it was under. Okay, under and after state socialism in the case study of the Czech Republic. She previously worked for Clifford Chance in Prague and also trained at the legal service of the European Commission and the Court of Justice at the European Union. Today she's going to speak to us about anti-discrimination law in Central Europe. And before she starts her presentation, she's very lovely asked me to ask if we could actually all introduce ourselves very quickly so she knows who we are, which is an innovative idea. So I guess I'll start. I'm Konstantina Isidoros. I'm an anthropologist here at Oxford. Probably been here as long as you have. I have dabbled a bit in international law, but really looking forward to your talk today. So I guess we'll go around.
Yeah. My name is Anna. I don't study in Oxford, but I live in Oxford, and I represent here two faces. One face is a civil society organization based in Armenia, which is in Eastern Europe, and we are campaigning for anti-discrimination law, which is very welcome to get information from you. And my second face is to represent Women's Fund, which is based here in Oxford, and it's called the Solidarity Fund, which is seeking funding and support for women's grassroots organizations in South Africa.
I am Hamza, and we know each other, but I'm doing a DPhil in social policy, looking at domestic violence in Tibet, and also looking a little bit at civil society activism around women's rights in the area.
So my name is Toby van Leijten. I have a PhD in comparative literature, and I study and act against female-genital mutilation. I'm a teacher, supporter of IGS.
I'm Rosalind Marsh. I'm Professor Emeritus at the University of Bath, and I've written quite a lot on women's rights in particular, including a little bit about Central Europe, but mainly about Russia.
I'm Margaret, and I've been around a long time in women's studies and anthropology.
I'm Jeanette Davis. I'm also an anthropologist, predominantly medical anthropologist, and I've been here at International Gender Studies since the early 1990s.
I'm Matt Hurley. I'm a lecturing associate at Oxford Brookes University, and my research is around gender war and militarism, and I'm a newly minted research associate here at IGS.
I'm Carrie Thornhill, and I'm working as an IGS research associate. I also work as the academic mentor for the Masters in Women's Studies. And Barbara, I think you know me.
Hi, I'm Daniel Smith. I'm a colleague of Barbara's from Lincoln. I'm in the English faculty. I work on women's writing, and I'm half Polish, so I'm interested in this topic.
I'm Alison Jewell. I'm a visiting research fellow here with the IGS, and I'm a professor of education back home in Canada.
I'm Professor Judy Goatley. I'm associate at the School of Anthropology. I work mainly on gypsies. My former student gave a paper here this term from Warsaw, who's professor in Warsaw. I taught her in Denmark, and I was first woman with the Oxford Union as an undergraduate. And I met Malcolm X.
We can just wrap up and we'll go home. Thank you.
I'm Maya Bakaya. I'm from Georgia. I'm here Women's Employment Research Fellow at IGS, and I'm doing gender studies, social movements, and informal labor research.
And I am your terribly efficient administrator. That's a faceless voice behind the camera.
Would you like to introduce yourself? She's got a question. I teach.
helpful because I think I know that the center is very interdisciplinary and people here work on different places in the world, look at different issues. So it's helpful for me to know a little bit about who will have what knowledge or pre-knowledge on the topic. The talk today, I think I should say a little bit about methodology, but also the geography on this. So although I call this Central Europe, I should really say I will be looking at the Czech Republic. That's the country that I work on in greatest depth. Obviously, this means that some of the conclusions or the propositions that I'll be putting forward, I think some of them will be more generalizable, but some of them will be limited to the Czech Republic. There are obviously idiosyncrasies that countries in Central and Eastern Europe have. Among the ones that Czech Republic has, and I think should be highlighted, is, for example, the actually relatively weak influence of religion and church, which in some ways is really good for it compared to its neighboring countries like Poland or Slovakia. On the other hand, it also has, I think, has had a very specific and very strong neoliberal turn in the 1990s. Again, which I think partly because some of the conservative and church influences in other countries was not as strong. So this sort of value-free market, the invisible hand narrative was particularly strong in the Czech Republic, maybe in ways that it wasn't in other countries. I would probably go on and we can maybe come back to it in questions and answers, but this is just, so that I think there are advantages of a single country case study. I know it very well and I can go in depth, but also obviously I have to be careful about some of the conclusions. The other important thing to mention is that a little bit, I'll be talking about the EU and the role of EU, and I think there's another important divide between the countries in Central and Eastern Europe, which are now members of the EU, with all the legal obligations to implement directives, be it on sex, gender equality, or other grounds like race, sexual orientation, etc., and those which aren't. So I think that's another thing to bear in mind. Methodologically, I like to call my research like context. I start with looking at the development of legal regulation, but I go a little wider. I basically do a genealogy of the conceptual underpinnings of the legal regulation, especially sort of inequality and anti-discrimination would be things like comparison, ideas about motive or intent, bias, sexism, and things like that. But I look at those not in sort of the widest societal context, but I look at them as relevant for the adoption or application of legal regulation. So in terms of sources, this would be things like explanatory memoranda to proposals of bills or laws, parliamentary debates, its legal scholarship, and its judicial interpretation and application of the law. So it's reasonably narrow in terms of my source material, but understandably because of my experience or my discipline. So just to start you off with, to give you a little bit of an idea of the discourse in the Czech Republic. This is a Senate declaration. That's a very rare tool that I actually have not seen used for anything else than the Anti-Discrimination Act, which was being adopted in 2008 in the Czech Republic. And it is a statement the Senate adopted, basically saying we're doing this, but we really hate doing this. So the Senate voted to say that the Senate considers the Anti-Discrimination Act a tool for implementation of the requirements of EU law, the non-realization of which would lead to sanctions. It does not, however, identify the character of the norm, which artificially interferes with the natural evolution of society, does not respect cultural differences among the member states, and elevates the demand of equality above the principle of freedom of choice. The Senate urges the government not to consent to adoption of further anti-discrimination measures at EU level. There are a couple of things to sort of highlight that I'll be coming back to. It's partly this idea of the cultural specificity. There's a lot of ideas of naturalness, and natural development, and the freedom of choice is something that I already mentioned. It's a particularly strong neoliberal understanding of freedom and equality as being close to each other. In the talk, I'll first speak a little bit about the comparison between East and West, and I know the anthropologists among you will dislike these labels, so I'll try to explain, and obviously we'll hope that you forgive for this simplification. But I think it's important to realize that the development in state socialist countries with regards to equality and anti-discrimination happens slightly differently. That can explain a lot about where we are today. And then I'll do a little bit of a chronological assessment of what happened under state socialism and what happened after. I call all of the post-communist period transition And I know there can be objections to that as well. I see it more as a transition from something rather to something. And I think it's not entirely incorrect to see that process has not yet concluded. I think some of the, for example, the divide that has opened in regards to the treatment of refugees shows us that countries in Central and Eastern Europe have not really yet fully joined, I think, Western discourses, understandings, etc. So my claim in terms of the different trajectories is that Central and Eastern Europe is out of sync with Western Europe, or what would have been the old members of the European Union, and I will be using the example of the UK in particular, in terms of the phases of equality and anti-discrimination law. So somewhat simplifying, in the West we can first start with a first period, which is the elimination of legal privilege, or equality before the law. So this would be things like adopting women's voting rights, property rights, guaranteeing to some extent or equality, or not to some extent, but in some countries this would have happened during this period, sometimes later, equal access to divorce. So it's basically the stage at which the moments in which law itself distinguishes and discriminates between sexes is eliminated. At that point, I think Western and Eastern Europe have actually, they've gone through this together. So there is not a huge distinction up until sort of mid-20th century. As a matter of fact, some Eastern European countries adopted, for example, voting rights, universal suffrage, for women earlier than some of their Western counterparts. So Czechoslovakia did it in 1920, whereas a lot of Western European states only did it after the Second World War. So this is not some kind of a inherently backward region. The second phase that we can identify in the UK and the western part of the EU, or the old member states of the EU, is the moment of adoption of anti-discrimination legislation. The intellectual step needed for that is, I think, that you realize that just eliminating formal legal discrimination or distinction between the sexes is insufficient to actually address real inequalities in society. And you start adopting legislation that prohibits discrimination both in relation between the state and the individual, but also between individuals. So this is the adoption of anti-discrimination legislation that prohibits discrimination in especially in employment, but also in access to education and access to publicly available goods and services. So this, in the UK, it would be 1965 Race Act, racial relations. I would have to look at the name again. In the context of the US, this is the Civil Rights Act. In the context of the EU, this is in the 70s, especially the adoption of directives on equal treatment or equal pay. And this is where Western Europe and Eastern Europe diverge. The third move or phase in the West is based on another understanding, which is that the mere prohibition of discriminatory behavior is probably insufficient to actually address the real inequalities. And you get a more substantive and transformative understanding, where affirmative action, prohibition of indirect discrimination. So not just acts that are directly based on your sex or race, but that although a neutral criterion is used, such as you're a part-timer, or you don't have certain educational attainment, are now understood to actually impact disproportionately groups that have those characteristics, such as, for example, in the context of the US and race, the requirement of no criminal history or a certain attainment of educational standards. They are indirectly discriminatory. Similar things happen in the context of the EU to part-timers, mostly women. So you're using a neutral criterion, but the impact is mostly women. So this leads to a recognition, or is based on a recognition of sort of a structural system of structural inequality, of hierarchies, of potentially unconscious bias in institutions that leads to measures and policies which disparately impact the disadvantaged group. It is much more context-based than the previous phase. So in terms of timeline, the second phase started in the 60s and sort of continued on. The substantive transformative equality kicks off particularly in the 90s and in the 2000s. In Europe, again, you can notice this with the adoption of a wide range of directives and more grounds prohibiting discrimination in a wide range of activities around the year 2000. Now, my point is to say that in Central and Eastern Europe, we didn't first have this formal equality phase of prohibition of discrimination and then this more substantive transformative phase. We actually have them the other way around. But with a lot of caveats, obviously, because the substantive equality project that state socialism had was basically very class-oriented, was very limited in many ways. So the ground that was the concern was class or socioeconomic origin, but none of the other characteristics that we consider problematic in Western anti-discrimination law. So this means, in a way, that when Central Eastern European countries were adopting anti-discrimination legislation as part of their EU obligations, they were doing something completely new. This was that there were no antecedents to this in their legal systems, and there were very few intellectual underpinnings for these adoptions, which is, I think, partly what explains the reaction of the Senate. So let's look a little closer at equality and anti-discrimination law during state socialism. So as I said, there were equality guarantees. There was an equality project. And I said it was mostly about class, but sex was not entirely forgotten. Both of the constitutions, Czechoslovak state socialist constitutions, remembered it. I will not read through this to read it out there for you to read. Maybe just highlight a couple of things. These are statements of equality, but notice not so much about prohibition of discrimination. So it is not about that sex or gender should be to your detriment. It's merely that is an equality as an equal standing. The other thing to notice, I think, is how quickly the language goes from equality to special provision. So a very strong emphasis on difference and immediate link to pregnancy and maternity. And we'll look at that again later. So despite these guarantees, I spoke about caveats. And these are the most important ones. Firstly, and it's a point that I will not go into great detail today, because of the materialistic understanding of society and social inequality in Marxism, this was a very socioeconomically based understanding of equality. So equality was an equality of socioeconomic leveling. It was not an equality that had understanding for diversity or different identity or anything that would have to do with sociocultural aspects of inequality rather than socioeconomic. Which is why I used Nancy Fraser's distinction between redistribution and recognition. So this was all about a recognition understanding of inequality, a redistribution understanding of inequality rather than recognition. This has a lot of legal implications as well, because not understanding symbolic harm, or rather understanding symbolic harm, or sort of cultural denigration and affronts to dignity is really, really important in anti-discrimination law, especially to understand behaviors like harassment. But also in direct discrimination, where there's usually an element, both order discrimination for the matter, there's an element of real material harm, but there's very often an element of symbolic harm as well. So this is quite an important point for anti-discrimination law as well. The other thing that I've also just flagged, but will not go into detail in, is the collective versus individual aspect. When looking at guarantees under state socialist law, we must remember that they would not have been seen as individualized rights or entitlements. And even things that we might assume from a Western perspective would have that element, like abortion rights, would not have been seen as such in the context of Central and Eastern European socialism. So the example of abortion, which is not an anti-discrimination issue strictly speaking, but a wider equality one, the abortion legislation actually was not even called abortion, but interruption of pregnancy, which I think is in itself interesting. This is not about the fetus, this is about the woman and her pregnancy. So the act was already adopted in the 50s. The act that legalized abortion made it accessible. The woman has to state grounds, but saying socioeconomic grounds was a sufficient reason. There was a little bit of administrative hassle surrounding this, but actually abortion has been available in Czechoslovakia and the Czech Republic since the 50s. But the aims as stated in the preparatory materials and in the act itself is all about women's health, but as a collective good rather than an individualized self-determination or autonomy kind of right. I mean, we know that in the West, understanding this in the sense of women's rights or women's reproductive autonomy has not actually always itself served women that well before, for example, Supreme Courts, like the US Supreme Court. But it is an important distinction that what we see, the development, we must not necessarily interpret it the same way, even if it seems like a rights guarantee might not actually have that underpinning in that context. The three issues that I will talk about in greater detail is that there was no enforceable anti-discrimination right, the predominance of class, and the emphasis on difference. So let me look at those in turn. This will sound quite banal, I think, that there was no anti-discrimination right, but it actually took me quite a while to realize that's what really was going on in the legal regulation, that these were statements of equality without without the right to actually state that you've not been treated equally, that you have been discriminated on the basis of your sex or race or other ground. So the language, both of the constitutions but also the labor code and all the relevant statutory legislation, were of equal possibilities or opportunities of equal standing, equal access, equal engagement. And those statements are really important, but they did not have the legal power of an anti-discrimination guarantee. The other problem was that, at least in terms of the relationship between the Constitution and statutory law, so the Constitution would often be the guarantee of equality and non-discrimination. The problem was that in the state socialist system, the understanding of the law was such that the laws were seen as actualizing the Constitution. So you couldn't claim, for example, that a particular law is actually a breach of the Constitution, because that would just not be possible considering the understanding of the hierarchy. It wouldn't be possible for that reason, but also because there was a lack of remedies. So the Constitutional Court, for example, was not even supposed to exist for most of the period of state socialism in Czechoslovakia. It was then, the possibility was then open in 1968, but it was actually never established. So there never was a court where you could claim your constitutional right to equality. But the same can be said of, for example, labor disputes. Labor disputes were supposed to first go to the trade unions, but obviously they're Communist Party dominated. You then exceptionally could go to courts. I haven't found a case where anything like discrimination or equality issues would be litigated. But even there, these were not independent courts. And going back to the individual versus collective, the scholarly literature on this is was very strongly opposed to actual individual taking up their rights through litigation. So that was actually entirely closed up for women, but also for other minorities. And finally, this is a really important thing point about human rights more generally. There's an East German legal scholar, legal historian, Inga Margaret, who has written on this, looking at Western and Eastern Germany. And she said that, and something that I already foreshadowed with the discussion about abortion, that rights were just understood very differently in the legal systems of the communists or state socialist Central Eastern European countries. They were there for education and persuasion, their policy pronouncement, their directives to the legislature, but they were not seen as individual entitlements that would be enforceable through the court system. So basically, not only was there no anti-discrimination right, but even had there been, this would not have been seen as legitimately, a person could not really legitimately take it up, and even if they wanted to, there would not have been an avenue to do so. The thing that's important for the understanding transition is, I think, that during the entire period of state socialism, despite the equality proclamations, the intellectual step that law might need to interfere with real-life discrimination, so actions based both on bias or prejudice, was actually never made. So this then came, this was a very new concept in the new millennium, when anti-discrimination law was being adopted in Central Europe. And so this also, and I will speak about that later as well, but because the language of equality was seen as connected to the previous period of state socialism and transition, it was seen as already achieved and yet discredited. The problem was it was never really achieved. There are aspects of the equality project which were actually never really addressed. And so you have this this problem of trying to introduce something that many people think we've already addressed, but we haven't. And the argument is hard to make because the language of equality was so prominent in the previous period. It's hard to explain the nuance, how limited it actually was, and not extend it to certain discrimination grounds. I've already mentioned this, the importance of class. So equality is understood as aiming at socioeconomic leveling. It's interesting to read excerpts like that from a very prominent legal theorist from the 1960s, because very similar statements you can read in sort of 1990s, 2000s anti-discrimination theory literature coming out of the West. I mean, you know, these things are very, very true. This context-based understanding, the substantive understanding that this cannot just be about formal equality. If people are unequal, you have to look at equality of opportunity or equality of results. But in the minds of these legal theorists at that period, this was really limited to class and socioeconomic origin. The other interesting point is that during state socialism, and again, this is something that happens much later in a way in the West, is this understanding that law really needs to be proactive. Law is a tool for social transformation. Again, something that was very present in the right wing during state socialism, but again, something that's a bit of a poison pill in the transition period. Because when you propose that law needs to take steps to actually remedy inequalities or injustices in society, you immediately get the reaction of, we've already tried this and it didn't work. This is social engineering, this is a communist attitude to law. So some of these things then come to haunt us in a way in the debates that happened after 1989. I've been mentioning class and the fact that that was the only truly visible thing to the state socialist legislator and policymaker. They also saw women and men. What they didn't see was gender. And to some extent this is not surprising because we're talking about the 50s, 60s, 70s, and 80s. So at least for the first part of that period, not even in the West have we really been speaking about gender as a social construct. But in the 70s and 80s, that then becomes a problem that the intellectual isolation of behind the iron curtain really means that there's a sort of a missing intellectual development on the recognition of the social construct of gender. But it's even more interesting because there was an understanding of class as social constructed. So Marxism, in a way, gave feminism the ability to sort of almost disentangle the difference between what is biologically determined or just predetermined on one hand and what is actually socially constructed. So Marxism was quite able to see social order as socially constructed, changeable, not inevitable, just a product of historical circumstance, but it never translated it to gender. What's worse, because it saw itself as a system which eliminates social inequalities, the remaining differences or disadvantages that women were facing almost confirmed that those differences must be natural, because if this system cannot take care of them, then nothing would. So this almost created an almost worse trap than you can find in capitalism, arguably. The strong sociobiological understanding of sexes and their differences is, again, I'm just giving you an example of the type of language used. This is from actually the only book on women and the law from the entire period of the 40 years by a prominent legal scholar, a female legal scholar, Sandra Panova, who said that a woman, while of equal rights in society, is different from a man through her sociobiological function with regards to the sustenance of humankind, which leads to various differences in anatomy and physiology, in social roles, especially in relationship to offspring, etc. I mean, the well-known combination of description and prescription comes across here very clearly, and is something that plagued the entire period. This also has to do then with the strong emphasis, which I already pointed out in the legal documents, the emphasis on difference between the sexes and the need for special provision. So it's sort of one breath speaking of equality, but immediately speaking of difference. The difference between the sexes, for the reasons just mentioned, it was seen as natural. This has led to a lot of preferential or special treatment, like protection of pregnancy and motherhood, and really not parenthood, but very extended motherhood. There is an article in a sociological paper from the 1980s which says that children should be with their mother until they're 15 years of age. That in itself sounds really good, but it went very, very far, and it was very gender-specific all the way through in a way that ultimately, even in the non-market labor economy, for example, of states of Czechoslovakia, made women really led to a lot of disadvantage in what would be the labor market. It wasn't the labor market, but it was sort of the area of employment, because women, especially towards the end of the period, would be taken out to care for their children for extended periods. And actually, I think I should mention this as well, that because the period was not homogeneous, the depressing thing is that it started much more revolutionary in the 50s and became much more sort of push women into the private sphere. And the narrative of difference increased actually in the 70s and 80s in Czechoslovakia. So another example is in the 60s, when the labor code was adopted, night work and certain types of work were prohibited for all women. That pushed a lot of women out of work entirely. It also meant that first of all, there are also area exceptions to the laws where women's labor was needed. So it didn't really eliminate the problem of unsatisfactory conditions. But a lot of the seemingly protected legislation actually had either a direct or an indirect negative effect on women's economic independence, their ability to participate in employment, etc. So that was the first problem, is the extent and the gender specificity of all these protective measures. But the other problem was that worse treatment, namely discrimination, was then also not seen as a problem, as an affront to equality proclamations. Because if once you see the sexes as very, very different, you can always justify the differences. There was a persistent wage gap of 40%, for example. There was obviously a very stark horizontal and vertical segregation in employment. All those were then explainable by women's different abilities and preferences. And again, this is something that has been quite prominently carried into the thinking of equality and discrimination and transition. A couple of weeks ago, there was a decision by first instance court in Prague on discrimination of doctors, female doctors in wage. They're getting 100% less than their male colleagues for higher positions. And the court found no discrimination because the women were working differently from the men. It's staggering, but there is a basis of this, of just seeing women as different workers, different abilities, different way of doing work. And it makes discrimination claims then very difficult when this persists till today. So again, legally, this means that the understanding of what constitutes discrimination is limited. Neither unequal treatment per se, nor unequal results trigger suspicion in legal terms. And I already mentioned this, that the continued differences throughout the period were seen as natural and almost confirming the naturalness of the difference between the sexes when they persisted under a just system. Now, what happened in transition, again, I'm giving you a quote, this time from a court decision. This was about discrimination in access to employment. This is an obiter statement of the second instance trial court. And it shows a complete inability of the court to actually deal with a discrimination claim. It says, the court found substantial differences in the appraisal of the candidates by members of the selection board. However, since this evaluation was not based on objective measurement of knowledge, but on subjective perception of the personalities of the candidates, these differences are natural. Moreover, the court did not consider the quality of the candidates, like their expertise, experience, etc., as a decisive element in the legal evaluation, as the law addresses only the difference in treatment of candidates and distinctions made on the basis of sex, as regards the opportunity to obtain the position to be filled. Every person is an unrepeatable individual, and it is therefore impossible to find that someone is better for a position than the other. It is a complete relinquishing of any kind of judicial oversight. It also shows that there is no understanding, for example, that the employer actually at least should have some reasons that they could present to the court that show that this was not on the basis of sex. So quite a basic move of shift of burden of proof, which was already enacted and part of Czech law at that point that the court was supposed to apply, but just couldn't wrap their mind around applying. So what has been happening in terms of anti-discrimination law in the Czech Republic since the 1989? We now have an equality and anti-discrimination guarantee in the new constitution. But the Constitutional Court has seen 3 cases in the past 25 years, and always all 3 were brought by men. There was not a single case of sex discrimination brought by a woman. At the level of statutory law, the EU requirements on implementation of directives led to an adoption of an Anti-Discrimination Act. But it was transposed as late and as little as possible. So we acceded to the EU in 2004, and the law was only passed in 2009. All the amendments made to it in the parliamentary process by the subsequent governments who were proposing these laws were limiting the guarantees. There was even a point in the history where all the law said was, this law implements EU directives, but it did not actually contain a prohibition of discrimination. And somebody finally said, well, you actually have to have the norm that contains the guarantee there rather than just saying, paying absolute lip service to the international obligation, but not actually doing what the directives wants you to do. So, I mean, watching it almost at every step was just an exercise in trying to undermine the legislation as much as possible. The law, however, did eventually enter into force in 2009. The cases that have been brought have overwhelmingly not been won by claimants, even though they're very often very straightforward cases of direct discrimination that are almost textbook example in the Western UK context would be textbook example of telling your students the most simple situations, like I just said, wage discrimination of people contemporaneously employed in a comparable or even in a more responsible position, getting vastly disparate wage does not seem to compute as an act of discrimination. Particular problems with the application, with direct discrimination, is that the courts seem to be looking for fault and intent. They don't understand anti-discrimination law, as it has been understood pretty much since its inception in the West, as something that is targeting, is objectively targeted, there's an objective liability, it's targeting bias. It doesn't actually care whether or not you know and want to be discriminated. It doesn't actually even say necessarily that you're a sexist or a racist. All it says is you made a decision that cannot be explained by any other objective criteria, and what's left is that this would be sex. So that mental step seems to be particularly challenging. With indirect discrimination, which is, as I said, sort of the more structural of the 2 legal institutes that capture discrimination, you need a little bit of an understanding of how structural bias works or institutional bias works. And again, that structures which lead to disparate results would be suspicious or suspect, and then will have to be justified. And one of the main elements of indirect discrimination is that the increased difficulty for the members of the disadvantaged groups in fulfilling the seemingly neutral criteria. That's what the problem is. But again, the court does not seem to understand that. So in this recent case of tax rules on self-employed child carers, they said that the fact that the child carer reached such low level of income that he was subject to obligatory minimum tax was not a systemic, rather a random matter. Undoubtedly, even parents who care for children over 4 years of age can reach higher incomes and therefore evade the minimum tax obligation. So this is looking for this sort of, wild exception. It's like saying, even African Americans in the context of the US, there are some who don't have criminal records, and that means that, requirement bring no criminal records for certain kinds of jobs is not problematic. Well, it is, because there is this proportionality. So finding one person who can go against the sort of skewed system, that does not necessarily mean that the system is not skewed, but again, this is not something that the courts are quite able to see. So to summarize this, anyway, I think the problem there is that there is no understanding of bias, and especially structural bias. And I think part of the real problem here is not a legal problem, but it is an intellectual history problem, namely the complete intellectual isolation of the country in the 70s and 80s, where in the West post-structuralism came and feminist critique of hierarchies and patriarchy, which, you know, became, at least at some level, internalized in public debates. And I think, you know, even among lawyers who might not know that this is post-structuralist, but they would understand at some level the importance of structure and sociocultural or symbolic orders that one lives in and its impact on our thinking and our decision-making. This does not seem to be part of almost our and the lawyer's toolbox at the moment, and I think this is a big part of the problem. And it is a legacy, I think, of state socialism still, despite how long the time has passed. The other thing that is a problem is that the anti-discrimination law is viewed very formally and symmetrically. This is particularly exemplified by the male claims before the Constitutional Court, right? That it's viewed as, you know, this is both for men and women. And I mean, that's actually right. I would tend to agree with that. But when you start having a situation where it's mostly men who take advantage of sex discrimination and they win, whereas the women lose, then something is going wrong. And I think, again, this is in a way a reaction to the transformative equality project of the era before, that, okay, we can have this anti-discrimination now, but it mustn't be like the communist project was, namely very, very substantive and very, very transformative. So we'll stick to the most formalistic interpretation of these rules, which then leads to anti-discrimination will actually not really do what it's supposed to do in terms of counteracting biased decisions, perpetuation of inequalities, etc. And I've mentioned these, oh, sorry. So actually to conclude, the problem, as I said before, is not really in legal regulation at the moment, but it is in the processes of understanding, interpretation, implementation, application. This is especially true of the courts. And part of the problem is, as I said, you know, these legal provisions are new, we have no experience with them. And if anything, the history of equality undermines current discrimination guarantees rather than supports them. State socialists understand equality. But there is a strong extra-legal reason for this as well, which is how does the legal community, the lawyers and the judges in particular, actually understand social reality. I think anti-discrimination law is one of those areas of law where it's very hard to apply it unless you can actually assess how inequality and discrimination comes about in reality. Exactly things like perpetrators or discriminators will often not actually be conscious of discriminating, or they might not actually want to do this. This will end up coming through from their unconscious bias in the way they set things up, for example, in the area of wages or job promotion. And so at the moment, in a way, the challenge is not strictly legal, it is of an extra-legal understanding of inequality, discrimination, social hierarchies, how does inequality come about, and how does discriminatory decision-making actually come about, whether it's in individual cases or structural. Okay, I'll end here. I know that I've kind of gone quite wide in terms of what I brought in, but I thought I would try to not be terribly just legal about it. I'm obviously very much looking forward to your questions, but also a couple of my papers are available on academia.edu, so if you want to have a look at this further. And I'm also very happy to be in touch with you, so write me an email.